Oh, they switched this around.
Welcome back. Be seated, please. All right, our final case for this morning is Wesley Johnson versus DOR on behalf of Lisa Andreone. So let me reset our clock here. Would you like to reserve some time?
Yes, Your Honor, I'd like to reserve 5 minutes.
All right, sir. Whenever you're ready.
May it please the Court. My name is Carlton Pierce of Carlton Pierce, PA. I represent the appellant, Wesley Johnson, in this case. Is my voice loud enough, Judge?
Maybe you could speak up just a little bit. We're getting old.
I could hear you fine.
Okay. I believe that these are the undisputed facts, specifically that the Department served this complaint stating this authority was pursuant to 409.2561.
All right, paternity was not, contested, and your initial brief seemed to take the position that if anything was in dispute, then the hearing officer no longer had jurisdiction and had to go to circuit court. You seem to back off that position a little bit in your reply brief. What is your position on that? If anything is contested, then the jurisdiction goes to the circuit court?
Well, not quite anything. For example, if you're talking about something of minutia where we're
where are you coming up with this distinction?
409.
Well, let's say that the name was contested.
If the name is contested, it's not paternity. We're talking about the paternity.
Well, paternity in this case wasn't contested.
That's correct. Paternity wasn't contested. However, they filed pursuant to 409.2561. If you filed pursuant to that, they stated that that was the basis of the jurisdiction. There are certain procedures that must follow from there. And in this case, my client did in fact follow those procedures. One, not only did he file an answer, but he filed a counterpetition. After filing the answer and counterpetition, that was...
But the answer didn't contest paternity.
No, it did not contest paternity, Judge.
All right. So why can't the hearing officer go ahead with child support determination, and then you go to circuit court? The circuit court has authority to, after time sharing is determined, to review the child support award. But in the meantime, at least the father is actually having to pay some child support for the benefit of the child.
Yes, but that's a two-step procedure, and that's very similar to what happened in Bernardo.
Now, in Bernardo, paternity was in dispute. I mean, if you look at the holding of Bernardo, the whole issue in Bernardo was paternity.
Yes,
and
but
then the court says, no, you're entitled to a jury trial. Hearing officers can't conduct jury trials, so therefore it has to go to the circuit court. Well, you don't have any jury trial issues in this case.
Well, the time sharing was contested, Judge. So again, getting back to the statutory provisions, the statutory provisions is that if there is an answer, specifically a counterpetition filed, whereby there is time sharing that's being sought.
What case do you have for support of that position, that if time sharing is in dispute, the hearing officer is divested of jurisdiction?
No, it's not the case. It's the statute itself, Judge. It's what the statute actually says.
So you have no case law that interprets the statute in that fashion?
No, Judge, and I wholly stated that. I stated that realistically this appears to be a case of first impression as far as the facts of this particular case. I was unable to find a case directly on point, and I do not believe that opposing counsel was able to find one directly on point either in reference to 409.2561 and the provisions.
And is there some public policy that you think advances your position? Is there some policy involved?
Of course, because, yes, Judge, because...
What would that be?
Well, one, if you're looking at judicial economy. Two, if you're looking at the right of the person to actually have the matter heard. He's looking at having his issue of time sharing heard. He's already filed it. He did exactly what the legislature stated, which was to file it in circuit court and to serve the department. In this case, that is exactly what he did. And according to the provisions in 409.2563, it should have been terminated at that point, and it was to proceed in circuit court. And that's exactly the position that I've taken, and that's the position.
And the prejudice to your client would be what?
The prejudice to my client automatically would be if he has to wait, and then if he has to wait, I'm talking about as far as time sharing is concerned.
Okay.
If he has to wait for time sharing, which he has had to do, if that's the case, he's being harmed from there because I don't have any young children, but I would believe that that's very precious to a father.
All right, but this is about child support, though. That's all the hearing officer did in this case was make a finding as to child support.
Well, obviously, with my brief, I don't believe that because there was an outstanding issue. The counter petition was on the table at the time period, and the hearing officer said, well, we're not going to deal with that. The only thing we're going to deal with is time sharing. Well, time sharing and child support are inextricably linked. So therefore, if that occurs, my client is without recourse as far as the time sharing because by entering it pursuant to 742, by entering it without a finding of time sharing.
Did the hearing officer in this case make any ruling in terms of the time sharing?
No.
So it's at the circuit court level, which is where you say it should be anyway.
That is correct.
Okay, so the only thing that the hearing officer did was make a determination as to child support.
No, because if a final judgment is entered without a finding of time sharing, sole custody goes to the mother.
Well, if paternity is not in dispute, that by statute is what occurs anyway.
No, only if a final judgment is entered that does not include time sharing. And that's the harm to my client, where automatically, had those provisions been followed.
But your complaint isn't that the hearing officer wouldn't hear the time sharing. Your complaint is that the hearing officer heard the child support.
No, my complaint is that the hearing officer did not have jurisdiction. And the reason the hearing officer did not have jurisdiction was because...
You end up in the same place. The complaint that you have is that the hearing officer made a finding in terms of child support.
That's part of my argument. That is correct. And the reason why is because the time sharing issue was there. 12.491 says that they can't hear a contested paternity matter. And I believe that the case revolves around the point on what exactly is contested. If you look at contested, if you look at what the Florida Supreme Court had stated, that's just in the instructions. If you look at that, it says that...
So if the name was, if contested means means well, the way that it's defined, which is anything is in dispute, if you wanted to challenge the name that was given to the child, that's contested.
I think in the broadest sense, if it's pursuant to 409.2561, I would have to agree with you, but the person would have to file that action in circuit court. And if the person did that, unfortunately, it would appear that that would be one of the conundrums of the statute, because the statute specifically points out time sharing. It doesn't point out the name. And be that as it may, and I understand the issue that the judge is directing me to, but what we're saying is that he, in fact, did comply with the statutory provisions. He did state that he wanted time sharing. He presented a time sharing plan. And pursuant to the statute itself, from that point, it was contested. And it's my argument today that the hearing officer was divested of jurisdiction because of the procedures that were followed. Because there's no question as far as...
If you prevail, where does that take you? It would undo the child support order, and time sharing still hasn't been resolved apparently.
That's correct.
I mean, all it really does is it takes the time sharing, which you want in the circuit court and which is still in the circuit court, takes it there, and it really just makes the circuit court make a determination on child support. Is that right? Well, I'm just trying to understand, as a practical matter, if you win, where does that get you?
Well, one, if you did the time sharing and the child support together, there would be a difference. And besides for that,
Well, there might not.
well, there might and there might not. It depends on the time sharing that's given.
Well,
That's correct.
it could make a difference depending on how much or who ends up with the majority of the time with the child.
Yes.
But if that were to happen, couldn't that be adjusted? Couldn't you make those adjustments so that it worked itself out? In other words, if it ends up, a time-sharing arrangement isn't going to change the gross amount of child support. It's just going to change who's getting the child support or who's paying it, what percentages, right?
Correct.
And so, and what is the statute that, you get some credit if you have more than, was it 40% of the time or something?
20%.
20%?
Yes, Judge.
So if the father ends up with more than whatever the statutory period is that would allow a reduction, couldn't you make that adjustment on the prospective child support so that it kind of worked itself out? I'm just trying to understand the practical side of things.
Well,
I mean, if they come back and say, well, you've been paying $100 a month and you should have only been paying $80 because of the time you spend with a child, couldn't you recover whatever that overage was in your prospective support?
mathematically, yes, but you can't recover the time with the minor child.
But there's nothing that we're going to do that's going to impact that anyway.
I fully understood, but
why couldn't you have just gone with the time-sharing portion of it and set a hearing in front of the circuit judge? I mean, laying all of this other stuff aside, let's assume that you're right, and let's assume that the child support hearing officer shouldn't have done that. What precluded you from setting your time-sharing issue in front of the circuit judge a long time ago and getting that issue resolved?
Well, certain steps have, in fact, already been taken where, certain things have already been taken because there are certain procedures that have to be followed. And
Or you have to go through mediation.
exactly, right, and those things. So now it is at that point where
It just takes that long for the circuit court to get to it because of their caseload.
the 18th Judicial Circuit has a very heavy caseload.
But meanwhile, I assume that the state is paying money for the benefit of the child, correct? Is that right? Is this a case where the mother's getting some sort of assistance?
Well, at some point she was. I'm unable to state whether or not I'm unable to state even at the time of the hearing whether or not, in July 25th, I'm unable to state whether or not at that time she was receiving any benefits.
But the fact that paternity is in dispute, the natural father has some obligation to assist in the support of the child, pending the determination of the time sharing, correct?
Yes, Judge, and if you look at the record states that my client was in fact sending funds, and according to the transcript, it turns out there was approximately what the child support was determined to be by the hearing officer.
Slightly less, right?
So my client has never shirked that responsibility. However, again, when you look at the prevention of him seeing the child and the fact that
But this case isn't about the prevention of him seeing the child. This is simply about the jurisdiction of the hearing officer to make a child support award. There's nothing that we can do to speed up, the circuit court, to give him time sharing.
Understood, Judge. That's completely understood. But again, if we're looking at the statutory provisions, and the statutory provisions would demonstrate that...
So the only thing gained, if we rule in your favor, the only thing gained would be that this slight difference between what he was paying and what the hearing officer awarded, that's the difference. That's what we're talking about here.
No, I do not believe so, because although opposing counsel argued that there's not a substantial change in circumstances that would need to be raised, if it's pursuant to, one, as far as 742 is concerned, it has to be a final judgment entered pursuant to 409.
Or you said he'd been paying child support.
That's correct.
So the only difference is between what he had been paying and what the hearing officer ordered. You know, there's nothing, you're not going to go back and say, well, he should have had additional time sharing and didn't get it, so we want to retroactively go back and adjust child support because now you're going to give him this extra 20% or whatever the court would determine in terms of child support. You're not going to go back and undo anything because of that, correct?
That's correct. It's not possible. Mathematically, you can probably work out whatever happens in the future,
Right.
but you cannot recapture the past time sharing.
Okay.
May it please the court, my name is Bill Branch. I'm an Assistant Attorney General with the Office of the Attorney General, and I'm here on behalf of the Appalachia Department of Revenue. The position of the Department of Revenue is that what the court should be looking at is whether or not the specific issue of paternity is contested or not contested. If it's not contested, then the hearing officer had jurisdiction to enter the order that was entered. And in this particular case, it's clear from the record that paternity was not contested, therefore the hearing officer did have jurisdiction.
Well, but you certainly don't disagree with the idea that if time sharing was worked out so that the natural father got additional time sharing, that would have an impact upon child support.
Absolutely, and Your Honor, it happens all the time in these DOR Title 4D cases to where you get a support order entered, they subsequently go and they get time sharing, and there's an adjustment to the child support. It happens all of the time, so that is not an issue. Any more than there was an issue that when the hearing officer entered the child support order under the statute, custody defaults to the custodial parent unless there is a determination made, and the statute says without prejudice, therefore there was no roadblock to the father moving forward to getting his time sharing, and then once that occurred, going ahead and adjusting the child support. So I think that's a very simple issue to resolve. One thing I would like to address, and there's been discussion by the appellant today and also in his briefs regarding the application of the statute. And the appellant talks about 409.256 and 2563. Those are administrative statutes. This is not an administrative case. Neither of those statutes apply to this. This case was filed in the circuit court as a paternity and child support case. A summons was issued by the circuit court. The answer was filed in the circuit court. A hearing officer is in effect a judicial officer, not an administrative officer. If this was an administrative case, the hearing officer would be a Department of Administrative Hearings hearing officer. That is not the case in this particular case. So 256 and 2563 have no application whatsoever in this case. And I just want to bring that to the court's attention so there isn't any confusion when the court considers a resolution to this case. The purpose of the hearing officer rule is to have an expedited process. In this particular case, that's what happened. We had child support based on appellate's counsel's comments today. They haven't even gotten to time sharing because, as he said, the backlog of cases down in the backlog of cases. If we took the appellant's position, we wouldn't even have a child support order at this time. So the whole purpose of the expedited process is to ensure that money is going to the children. That is what occurred in this case. It was an uncontested paternity case. We do not believe under the facts of this case that Bernardo applies. Bernardo clearly was contested. He contested, in fact, the DNA results of 99.97. In this particular case, the father has always acknowledged that he is the father. So specific issue of paternity not being contested, when that occurs, it doesn't matter what else is contested within the case. It does not turn that paternity case into a contested paternity action. Only the specific issue of paternity being contested can do that. And unless the court has any other questions, I think based on the questions that this panel has already asked, there's clearly an understanding of the position of the department, and we would ask that the court affirm. Thank you.
Thank you, sir.
May it please the court. Opposing counsel stated that this is not a 409 case. However, if you look just at the face of the complaint, it states the jurisdiction under which it's operating. In this case, it was on page 833, and that was the appendix on the initial brief, specifically states pursuant to Florida Statutes 409.2561, a recipient of public assistance to the department. It gives to the department any right, title, and interest to support the recipient may be owed. In this case, I believe this is clearly a statutory case under the administrative proceedings under 409, although there is an overlap with 12.491 because pursuant to 12.491, yes, a final judgment could be entered, but if, as he stated in his brief, 742 is to have of any import, 742 is based on final judgments granted pursuant to Chapter 409. Otherwise, the final judgment would not, in fact, at least I do not believe that it would have any jurisdiction unless, pursuant to 742, unless it came under that statute. And I'm only talking about the issue before the court. There are other ways to get a final judgment in under 742. However, in this case, it would fall pursuant to 409. And that's exactly what the department at the trial level stated that it was proceeding under. Again, pursuant to the statutory provisions, we believe that the trial court erred, and we believe that the trial court should be reversed, and I request that the trial court be reversed. Thank you. Thank you.
Thank you both. All right, have a safe trip home.
Thank you.